Okay, so what is D&O insurance? It started out being insurance for directors and officers, but as I said, it's a lot more than just that. It includes individuals beyond the D's and O's, and we'll talk a little bit about that, and it also includes insurance for the organization. So any wrongdoing on the part of the organization itself, if the organization gets sued, it is insured under the policy and can access the coverage available. The policy covers loss, including defense costs, and I say including defense costs because you could do absolutely everything right, have done absolutely nothing wrong, and still anger someone enough to bring a lawsuit. So you may think you're doing a great job, and you probably are doing a great job, but at the end of the day, if somebody takes issue with that and decides to bring a case, as frivolous as it may be, it could cost lots of money, and this policy would assist in paying for those costs. So it's loss, including defense costs, that result from a claim made in the policy year, and we'll talk a little bit about that, alleging a wrongful act, and we'll talk a little bit about what that entails, on the part of an insured individual and the organization. Oops. Oh, there we go. All right, so let's see where we are. Back to who are insured, so slide 4. Keep going forward, sorry. That's it, there we go. So as I indicated, the organization is an insured, but in addition to the organization, you have individuals, and basically this is the definition that comes right out of the policy. So you got a past, present, or future, and that means basically anybody from when the inception of the organization right through to anybody who may come on board later on. So past, present, or future, director, officer, trustee, department head, committee member, staff or faculty member, employee or volunteer of the organization. So it's not just the directors and officers. It basically encompasses everybody who is involved in the organization, whether they're an employee, whether they're a volunteer of the organization, whether they're a director, an officer, a trustee. As long as they're acting in their capacity as a volunteer, as a director, as an employee of the organization, they will be afforded coverage under the policy. So obviously, if you have a day job as well, and the person and you're doing things in capacity as an employee in your day job, this policy is not going to pick that up. But if it's hockey related, and if it's related to what you're doing on behalf of the organizations involved, then you are considered insured under the policy. All right. Yeah, thank you. So some key provisions of the D&O policy. It's a claims made and reported policy. Unlike your GL basically, whenever the incident happened, whenever the injury occurred, whenever the fall happened, that is the date that triggers the policy. In a claims made and reported policy, it's actually when the claim comes out. So, for example, the organization may have done something 15 years ago that somebody is taking issue with today, decides, hey, I didn't like what you did 15 years ago, I'm going to sue you today. It's the policy period, it's today's policy that would pick that up. And there's benefits to that, obviously, because if you weren't insured 15 years ago or you were insured with a different carrier, we don't care about that. We just want to make sure that you're picked up for the claim that was made today. Second point I wanted to make is it's not a duty to defend policy, which means you guys, in association with us, get to control what happens, who defense counsel is, who is appointed defense counsel, what happens in relation to the claim. These can be very personal at times, and we want to make sure that you guys are very much involved in the adjudication of the claim and how it proceeds. There's reputational issues that may be of concern that we want to make sure that are addressed when we're dealing with the defense. And so we ask you guys to partner with us in order to make sure that claims are addressed and handled appropriately. The flip side of that is if you guys don't want to be involved, you can say, you know what, AIG, take over. We don't want to have anything to do with it. You guys go ahead, make the decisions, and we're happy to do that. So you have the ability to tender that defense over to us, let us call the shots and take control, or you guys have the opportunity to partner with us in order to make sure that we achieve a resolution of the claim that works for everyone. Cooperation is important. Don't admit liability unless you've had an opportunity to talk to us, because that may jeopardize your rights under the policy. For example, you may say, yeah, you know what, we're wrong, we'll pay you $50,000, and that wasn't vetted through AIG. There may be reasons why you don't owe that money, or you're not liable, or the responsibility isn't there. So talk to us before you actually go ahead and make any sort of admissions of liability, before you actually make any offers to pay, because that may jeopardize your coverage under the policy, and we don't want to be in a position to tell you that you did something that you shouldn't have done, and therefore there's no coverage available. Limits of liability. So the AIG policy has a $10 million limit of liability. That's for all claims within a policy, within any given policy year, and for all members and organizations under those policies. So there's various organizations. There's beyond the Ontario Hockey Federation. All the the Hockey Canada policies have an aggregate limit of $10 million. Once we get to the $10 million for that any particular policy year, we tap out. There is, I understand, insurance above ours. There's an extra $20 million that other carriers have. I'm not familiar with the terms of those policies, but I would assume that they're follow-form policies, and they would then take over. So it's a total of $30 million, I understand, in total policy limits with respect to D&O for any given policy year. There is a retention. The retention is a $500 retention. It's fairly low compared to other retentions and other types of policies. So what that means is the first $500, whether it happens to be a defense cost, or whether it happens to be settlement, or whether it happens to be judgment, will come from you guys, and then we pick it up on top of that. There's also statutory obligations coverage, and this is really geared towards the directors. What that means is that in the event of a bankruptcy, the tax man can come knocking and say, you know what, directors, you are responsible for the taxes that are outstanding. Your employees can say you are responsible for the unpaid wages that are owed to us, whether the directors did anything wrong or not. This policy will backstop that. We will actually pick that up for you. We will pay those obligations that are imposed by the CRA as well as the employees. There is a sublimited penal defense cost coverage. So, for example, if there's criminal charges that are laid as a result of an incident, we will pay up to $250,000 in the aggregate. So in total, we'll pay up to $250,000, provided that you're found not guilty at the end of the day. And again, we're talking about all of those individual insurers that we talked about earlier. There are what we call conduct exclusions. So if at the end of the day it's determined that in a lawsuit that you were either criminal or deliberately fraudulent, our obligation to pay stops at that particular point in time. However, we will have paid up to the all defense costs up to and including that point. And there is a bodily injury and property damage exclusion. Todd went over the GL policy, and that really is where the BI and PD is really meant, bodily injury and property damage is really meant to be covered. So anything relating to bodily injury is not part of this policy. That includes, so there's also no coverage under this policy for sexual misconduct and child abuse, and that's all dealt with elsewhere. And the other thing that I would point out is that that's not on the slide. In the event that a team or an organization decides that it wants to sue one of its employees, one of its directors, one of its officers, that also would not be covered under the policy. There we go. So what is a claim? At the basic, so it's not just a civil proceeding or a criminal proceeding. We're not talking about just a lawsuit. If somebody writes a letter saying, you did me wrong and I want money as a result of that, that's a claim, and that's something that should be reported, and that's something that we could help you with, and that would be something that we would be able to cover for you. In addition, we're talking about lawsuits. If you're sued, please report that immediately in order that we can get the right resources on that, and we're able to take care of that for you. Again, we discussed who an insured was. The individual insured is very broad, so that includes people like volunteers, employees, part-time employees, seasonal employees, temporary contract employees are all included with respect to who an insured is. Wrongful act, it's a very broad definition of wrongful act. It basically reads a breach of duty, negligence, error, misstatement, misleading statement, omission, or any act of an organization or an individual insured. It includes employment practices claims. So if somebody says that they were discriminated against and therefore didn't get the job that they had applied for, or they were wrongfully terminated, they shouldn't have been fired the way that is being alleged, all that stuff is picked up under the D&O policy, so the D&O coverage will cover that for you. It includes a sublimited non-employment discrimination provision, so if there is someone other than an individual insured, so that broad list of people says I've been discriminated against for whatever reason, we will also backstop that, the cost associated with the defense of those types of claims up to a sublimit amount. Oops. So what do you do in terms what do you do when you think you might have a claim, or when you think when you're being sued? Report it to your branch or your member partner immediately so that they can filter that up to Hockey Canada and send it over to us. The policy requires that you report your claims within the policy year. If you do not report your claim within the policy year that the claim is made, there will be no coverage available to you under the D&O policy. So you can't wait a year and a half, 18 months, 2 years to decide, hey, maybe we should get our insurer involved. If you wait that long, you'll be out of luck. So as soon as you know that there's a claim, whether it be a written demand for money or any sort of lawsuit or proceeding, please put us on notice right away. If you think there might be something brewing, let us know. Because if you don't let us know, if you let us know, that locks it in, and we're in a position of being able to say whether the policy is triggered at that time or not. I never want to be in a position to tell you guys it's too late. All right. So once that happens, it gets filtered over to us. We'll review it for coverage. We'll see what coverage applies, what coverage what exclusions might apply, where we're at, and then we'll get back to you with respect to that. We'll then appoint counsel if counsel is necessary, and we'll work with you guys to make sure that we get an appropriate resolution of the claim. It's not always about money. Sometimes it's about reputation. Sometimes it's about principle, and we particularly understand that, and that's why we want to make sure that we're partners in the claims handling process. Okay. Those are basically my comments with respect to D&O insurance, but I'm happy to take any questions if you guys...
I know that some of our associations have D&O insurance through their municipality or what have you because their municipalities insist on it and stuff. So do the two groups just work together if something happens? Yeah,
in claim situations, and I do know that there are teams and organizations that actually have their own insurance. What would happen in that case is you would report it to us, you would report it to the other insurer as well. And then the insurance, then we deal with it on the back end to figure out how it's going to, how it'll play out. We try to make it as seamless for you guys as possible.
We do understand that some of the minor hockey association have coverage for that, but seriously, from my perspective, it's not necessary. Because, you know, they are well covered under the Hockey Canada policy. So, and we get a lot of phone calls year after years about that because, I don't know, and again, I think it's just a communication. It's just, we need to communicate that, but they are well covered. And I don't know if, Todd, you have anything to add?
Yeah, no, I agree. And I think it's partly on us, too, to communicate that down and to get it to the members because it's important. I think a lot of it is they don't know.
Well, there may be some that don't know, but I know in some cases the municipalities insist on it. They consider the Minor Hockey Association a part of the municipality, and all of their boards and committees have to have that representation through the municipality. So that's kind of where I was referring to. Thank you.
Yeah, I was just a little confused by a statement you made that if one of the teams in that association decided to sue the association because of whatever reason, that there would be no coverage? That confused me. Could you explain that?
What I was talking about is, let's say an organization decides, whether it be an association or a team has an employee. That's the most common example is if an association decides to sue an employee. So let's say an employee decides that they're going to pocket 50 grand. They're going to walk away, pocket 50 grand, and the association finds out about that. The association decides to sue that individual for that 50 grand. That individual would not be afforded coverage under the policy. So because the organization is the one that's bringing the claim against that individual, the policy wouldn't be triggered. And there's reasons for that. You wouldn't want that black hat individual accessing a policy that you guys are paying for through your premiums to defend them against a theft that he or she allegedly made against the organization. So that's really what that comment with respect to that was meant to cover.
I had a question. If there was a claim, here,
There we go, okay.
if there was a claim made against a league and its officers and directors based on the rules and protocols on return to play after a concussion, including a class action, is that a wrongful act that falls under D&O coverage, or is that under the general liability coverage?
So the scenario is it's an issue with respect to the rules of the,
Yeah, the claim, I guess, would be that the league's policies and protocols essentially are negligent by allowing players to return to play too soon.
if the underlying allegations of the player basically are that that they suffered an injury as a result of the league's rules, that wouldn't be the D&O policy that would cover it. I'm not a GL expert, so I couldn't tell you whether that's a GL type claim or not.
The GL for bodily injury, and obviously negligence is in there as well, so I could see it more to that side of things as opposed to the D&O side of things.
Okay, so if it goes under the general liability for that kind of a claim, what's the policy limit? I mean, I heard that on the D&O it's 10 million plus 20 million excess.
So general liability there's a $20 million limit plus another $50 million. So there's a $70 million limit at the end of the day.
Yeah. Okay. Thank you.
That brings up a good point. It's not necessarily this case, but there are other cases where you could very well have both the D&O insurance and the GL insurance respond to the same claim, depending on the various allegations that are contained therein, right? So that would, in those situations, you could have the benefit of both the 10 and the D&O limit as well as the GL limit.
Where and how are the associations paying the premium for this particular insurance that you're talking about? Is it part of the $16 Hockey Canada you spoke of earlier?
Yes, we cover that in the premium that's paid. You don't pay a premium for D&O.
How do you, do the association provide a list of every, like how deep does it go? Hockey moms, the juice mom, how?
It's actually not, we don't require a list of individuals or people named, so it doesn't have to be John Smith and Jane Doe in order to be covered. That list of, that definition of insured, so if they're a volunteer, who are volunteering at an event on behalf of the association, they are covered. They are considered covered under that policy if they're working on behalf of the organization. Obviously, the organization has to know that they're working on behalf of the organization. But if they're volunteering as part of that, and they're acting in their capacity as a volunteer at an event or for the association, then they are covered for it. We don't require a list. We don't require an individual. And if you have 1,000 volunteers, then those 1,000 volunteers are covered, are considered insured under the D&O policy.
And just adding to that, it's very important, and we don't require a list nationally either, but it's important that your associations know that if they're doing a tournament and they have a group of volunteers working at that tournament, that somewhere you've got that documented, that these people are working on that tournament. That makes everything so much easier at the end of the day.
Yeah.
Typically, I guess what you have is you have a volunteer board of directors, you have a league, and then you've got these associations within the league. And the associations have elected 16, 20, 25 directors who may or may not be registered with Hockey Canada. If they coach, they would be. If they're not coaches, then they're not in your system. But you're saying as long as they're part of that elected board, they're good.
Absolutely, yeah. And they're acting in their capacity as that board member or whatever position they're in. Then yes, they're good. They're considered insured under the D&O policy.
I just want to clarify that, though, that they're coaches that are registered, is that what they are, plus they're sitting on the executive, is that what you're saying? Okay.
I think the expansion of that is, what he's saying is, we're not registering our board of directors
Right.
unless they are coaches or are officials as well. So the question more, I think, was, are they covered? And those people are covered upon their election and when they elect them in, but also extending that out. If you bring in volunteers to to a tournament, those who are working for your association as a volunteer at that tournament, they would also get the extension of that D&O coverage to them. I think Todd's saying the key is get a list of those people at that tournament. Keep it internal. It doesn't need to be submitted to Hockey Canada, doesn't need to be submitted to the OHF or to the member partner. But if in case something comes up and there's a claim, you have a list of who are your volunteers at your tournament.
It makes it easier, obviously, at the end of the day to say, yeah, they were, we don't want to have to worry, were they a volunteer, were they not a volunteer, right? If they were, they were, and you've got that listed, that helps.
Yeah, a couple of years ago at the Hockey Canada Safety and Risk Management meeting in Calgary, we had a presentation from Christina Curry, and she mentioned certain things that were coming up as developing trends. And things like human rights issues, actions by players against each other for on and off ice incidents, and harassment and social media issues. Is that still the case, or are there any new trends developing that you may want to enlighten us on?
No, we're seeing, though that's pretty much what we're seeing in terms of where we're at, those types of cases. We are, I think you guys are all aware in the sort of the junior hockey field, there's a class action going on with respect to whether those players are employees or not. So that's sort of the big thing that's going on in the insurance world with respect to this type of situation. And we're all obviously taking a look at that and working through that as we go along. In terms of employee type stuff, we're looking at discrimination and harassment. That tends to be across the board, not just in your area, but all employers are seeing more harassment claims, more discrimination claims come through, employment-related harassment and discrimination. So we're seeing a bit of that. We are seeing some the same type of harassment issues about kids alleging coaches are being abusive, or abusive in the sense that they're being hard on kids, and bringing that up to human rights commissions. And so we are seeing a lot of the same types of things that Christina was talking about then.
Okay. Earlier, when the other gentleman was speaking, you'd mentioned that all of the volunteers, instructors, people had to be registered and paid their $16. Now we're saying that they don't. What is the difference between the two coverages that?
No, remember we talked about the Class 1, Class 2 volunteer. So the Class 1 volunteer are your coaches, officials, players. They are the ones that pay premiums. The other are the Class 2 volunteers, which are those around the game that are, I guess, documented as volunteers. So timekeepers, those types of things, they are covered under the premium that's paid by your Class 1 volunteers. Okay, so they don't, and they're not on the registry. They're not registered on the registry. Okay, so it's your core group, your Class 1 that pay that premium, that $16.50. Sorry about that if you missed that. I went by that pretty quick. So,
Todd, one that comes up and I've asked about before, and just if you could elaborate on it, is the CGL policy as it relates to offices of our organization, so our branch offices, our member partner offices, and what coverage is there specific in that CGL policy?
So the GL policy obviously covers the employees in there and anybody working for the association. Keep in mind, there's no property coverage there, so you need property insurance for your offices. So that's important to know as well. If there's anything else in the office that you're unsure of, make sure you check to make sure that the coverage is there, Phil. So. Oh, I'm sorry, and tenant legal liability, I should mention, is covered as well. So.
Can you just, one of the items was mentioned before was a competition between sledge and able-bodied teams. And Bill, maybe a bit of an expansion from your end on that. Was your question about sledge teams participating against able-bodied teams dressed as able-bodied teams, or able-bodied teams participating on sleds as well?
It would be, say, one of the associations, the father coaches his boy playing the minor hockey. He has another son that's into sledge, and they would like to play an exhibition game against each other. Both members of Hockey Canada, from what I understand, sledge hockey and the regular hockey. Just the type of permission or the coverage there for if something happened, because the boys that are able-bodied would be on the sleds.
and Phil, you can jump in here if you want, but as I said earlier, they're both registered, they both paid a premium. There's not a problem from that standpoint. The key is it's got to be approved by your branch. So if your branch has a policy or philosophy against that, then obviously it becomes a non-sanctioned event and it wouldn't be covered. But certainly if they're both registered, both paid a premium, then from that standpoint, there's not a problem.
So to clarify that one, from the branch perspective, our position has been if both groups are in the sleds, then it's good to go. So not a situation where you have one team in sleds and one team on skates doing able-bodied. We wouldn't cover that portion. But if it's a able-bodied group trying the sleds out against the sled team, we approve that. And then the other one I had is the injury report form, and just the importance and kind of re-messaging that to Todd about the importance of completing it accurately and getting that in.
Yeah, absolutely, Phil. Obviously, as I said earlier this morning, that form is the key to, I guess, that whole process with respect to the accidental insurance. And if you can get, if you can get team representatives to fill it out, that's great. Quite often the parents fill it out, and that's fine too. Some of the situations we see is sometimes it gets sent up the ladder into the Minor Hockey Association and sometimes doesn't get to us all the time. So it's always great to double check or have your members double check and say, hey, listen, did my form get sent up? Member partners, once it gets there, we get it pretty good. They're pretty quick and it gets approved and sent up to us. So that process is fairly good from that standpoint. But making sure it's complete, guys, and making sure that we have all the information, the physician statement, dental statements filled out. And then again, once we get that, then there's no problem with those receipts being sent directly to Hockey Canada to, again, help speed up that process a little bit. So.
And then the last one for me is just that re-emphasis, I think, both in the DNO and from the CGL policy, the GL policy, with regards to reporting claims up. The importance of doing that early, and maybe Joe and Todd, you can both reiterate on that topic, both actual claims that you have in and potential claims that are there.
Yeah, absolutely. If you get an inkling that something may be wrong and that there's a possibility that a lawsuit or some sort of demand may come out of it, don't hesitate to let us know. It's better to have us put on notice, take a look at it, and say, yeah, well, let's sit on it and see what transpires, than to wait it out or try to handle things on your own, go back and forth and try to settle or try to figure things out without letting us know, only to find out that you can't do it and bringing it to our attention late, and us unfortunately having to say you jeopardize coverage and therefore we're not going to be able to help you. I never want to be put in that position. So I would rather you let us know. It doesn't really, it doesn't affect us from an insurer perspective. If you do put us on notice, if it's something that's minor that doesn't transpire into anything, great. If it does, at least we're there, we're with you, and we're able to provide you with the resources needed to deal with it as quickly and efficiently as possible.
From a liability perspective, obviously it's very similar to D&O. If you have an inkling that something's going to occur, quite often you'll get a letter from a lawyer who, with an intent to claim, it may not be a statement of claim, but with an intent that they may be creating a statement of claim, that should be obviously forwarded to your member partner right away, and we should be made aware of that. Obviously, when the statement of claim is made, the same thing, we should get that right away. You may also get an email message or something that says we plan to position a claim, and again, we should be at least notified of that so Glenn can take whatever steps need to be taken from that standpoint.
Yeah, just to add on that, and just to give you an example of our day-to-day at the office, it's happening once in a while that we discover these type of probable claim by reading the paper or just on the internet. So we exchange a lot with Joe and Todd on a regular basis, but sometimes something happened the night before and it's in the paper or on CBC the next morning. So we report that ourselves without having the chance to speak with Sue or anybody. So anything can arise. Just make sure that the communication is there for that.
Okay, so to be completely clear, we're not waiting for a letter from a lawyer or somebody who's even stating an intent to sue. If it's even a parent who's lipping off, oh, you cut my kid, I'm suing you, you guys want to know.
Yeah, you know
There's
what?
going to be a lot of letters if we go with everybody who
Yeah,
just says that because they're mad today.
Yeah, and that's where common sense is used, and quite often there's a waiting period there, and you know what? That's fine. A few days is not going to jeopardize anything, and things settle down, and that's fine too. So I would just keep an eye on things, and if they start to fester and they start to build, that's when you want to make sure that you report it.
Yeah, I mean, if it's a few days, then that's not an issue, but if you're gonna, don't sit on it or try to handle it yourself, or if you're fine that you're engaging back and forth and nothing's coming of that.
Yeah, that's where you start.
Yeah.
I would agree. I was more just concerned that we were sending off a note every time somebody used the word sue in a
Yeah,
sentence
no,
or
I-
an email. The
Yeah.
minute they say it a second time, I agree with you. There's something there.
Yeah.
So I wanted some clarity. Thank you.